Hello friends, welcome back to a series of lectures. This is the 13th lecture of this series of Indian Evidence Act. So we are studying the topic rule of best evidence. And you see the parties required to produce the best evidence. Any party who produces the evidence, he has to produce the best evidence. For example, if the party is having the oral and documentary both, then he has to produce the documentary evidence. And if he is giving oral evidence, then oral evidence should not be hearsay. It should be a direct evidence, and so forth. If the party is having the primary and secondary both, then he has to give the primary evidence. He can give the secondary evidence only when the secondary evidence is allowed under section 65. So these are some cardinal principles of the law of evidence. Similarly, one important principle is that the court cannot sit idle. Suppose I am the judge sitting here and the proceeding is going on, then I cannot sit like a mute spectator without participating. I should be inquisitive. Inquisitive means जिज्ञासा रखने वाला. So I should be inquisitive to know the way it proves. Now suppose a witness comes and gives the evidence in the court and I am simply watching him. I find that I need to ask some questions. I expect from the parties to ask all possible questions. But at time I find that the parties in chief or in cross-examination have asked questions but not asked all relevant questions which needed to be asked. And even as a judge, I have some questions in my mind. Then should I not have given the power to ask question myself from him? जैसे you are a lawyer, you produce a witness, you examine him in chief, then the opposite party cross-examines him. But I find in the course of cross-examination that there are certain points which ought to have been asked and which have not been asked by either of the parties. Then is it not my discretion or my duty also to find the real truth of the evidence? Is it not my duty and the discretion to put those questions myself? अगर कोई उन questions को नहीं put कर रहा तो मैं खुद उनको put करूं. Because judgment should be based upon facts which are relevant and which are duly proved. And if a fact is duly proved, so obviously when a witness comes into the court, the witness gives the testimony of a fact. And in order to have the fact duly proved and to examine whether it is duly proved or not, I must also be given the power to ask questions myself. Similarly, if I find that a particular document ought to be produced into the court, but the document is not be produced by either of the parties, then should I not have the discretion to summon the document and examine the document? Suppose there is a criminal matter and the investigating officer has submitted the case diary. Investigating officer ने case diary को court में produce किया. And in the investigating officer, in the case diary, it has written that he has investigated A, B, C, D, etc. And in the case diary, he note down jottings of the witnesses who he had examined, if you are little bit aware of the CRPC. Now he has written the jottings of A, B, C, D, examination of A, B, C, D and E, A, B, C, D, E. इन 5 लोगों को उसने एग्जामिन किया, लेकिन प्रोसिक्यूशन ने सिर्फ A, B और C को विटनेस बनाया. The prosecution has called only the A, B and C as witness. D and E as not called as witness. Because maybe the prosecution does not feel that they are the very important witnesses. But when the court read the case diary, it found that the statement made by D and E is also a very relevant thing, and D and E must also be examined. Now the prosecution not produced the D and E, Defense is not also not producing D&D. The list of witnesses is filed in the court and D&E is not mentioned anywhere. So here, for its own satisfaction, the court for its own satisfaction believes that D&E should also be examined. Then can the court summons D&E for its own and makes them court witnesses. The court D और E को भी सम्मन कर सकता है अपने satisfaction के लिए और उनको खुद एग्जामिन कर सकता है, and that witness who is directly summoned by the court will be called the court witnesses. So basically the point you have to appreciate is that the ultimate final decision of the case lies in the hands of the judge, and he has to ensure that the interest of justice shall be done, and he has to ensure that for the interest of justice, proper decision of the suit or proceeding, all possible efforts shall be made. All possible effort means all concerned witnesses, all concerned documents shall be presented. And if he finds that some witnesses or some documents which is important and not produced, then the court has the power to summon that witness or that document. Similarly, he also has the power to ask questions to the witnesses presented by the parties concerned, and he also has the power to ask questions directly to the parties, because ultimately it is the satisfaction of the judge which will matter, because ultimately he who has to decide the case. There always a limitation upon him that he can decide the case only upon the relevant facts and which are duly proved. But the ultimate satisfaction lies in his hands, and therefore he has the special powers to ask questions to any witness, to ask questions to any parties, to summon any documents, and also if needed he can summon any witness. Or suppose the prosecution produced a witness, the witness has been examined, the witness had gone back. Then later on that judge realizes that I need to ask some question to that witness, then he can resummon that witness for himself. He can resummon that witness itself for satisfaction of court, and he can ask questions from the witness, and after asking the question from the witness for its own, he would record them. So ये जो proceedings हैं, किसी भी witness से कोई भी सवाल पूछ लेना, किसी भी पार्टी से कोई भी सवाल पूछ लेना, किसी भी डॉक्यूमेंट को सम्मन कर लेना, या फिर किसी विटनेस को सम्मन कर लेना. This is what the special powers of the court, and this is covered under section 165 of the Evidence Act, read with section 311 of CRPC. 165 में Evidence Act में you are asking questions, you are summoning documents, and in 311 CRPC you are summoning the witnesses. So witnesses को सम्मन करना, that is 311 of CRPC, और डॉक्यूमेंट सम्मन करना और witnesses से सवाल पूछना या पार्टी से सवाल पूछना, that is under 165 of Indian Evidence Act. So I am just telling the background of this section. अब इसको पढ़ेंगे एक बार, बट उससे पहले प्रीवियस लेक्चर में हमने पढ़ा था 92 प्रोवाइजो 2 और इलस्ट्रेशन डी ऑफ सेक्शन 93. इसके ऊपर एक क्वेश्चन आया है कि व्हाट इज डिफरेंस बिटवीन these two. 93 illustration D is talking about the blanks in the document, and 92 proviso 2 is talking about the things upon which you are silent, and it says that if there is an oral agreement on those points, then those oral agreement can be proved. And 93 का illustration B, that if you have signed a deed and you have left blank, in this you are deliberately leaving the blanks in a deed. आप किसी क्लाउज पर साइलेंट नहीं हो जो कि प्रोवाइजो 2 में है, आप किसी फैक्ट्स पर ब्लैंक रह गए हो, छोड़ दिया उसको ब्लैंक, खाली छोड़ दिया, रिक्त स्थान. और मान लो उसको अगर साइलेंट मानते भी हो तब भी 93 में सेपरेट ओरल एग्रीमेंट की बात नहीं हो रही है. दे आर नॉट टॉकिंग अबाउट द सेपरेट ओरल एग्रीमेंट. तो सो वी आर टॉकिंग अबाउट ए सिचुएशन. मान लो एक डॉक्यूमेंट है जिसमें यू हैव लेफ्ट सम ब्लैंक्स. देन विल नॉट द 92 का प्रोवाइजो 2 will apply and that separate oral agreement regarding that blanks can be proved? The answer is yes, why not? But again, it has to be seen that whether the document is silent or there is deliberate leaving of those blanks. अब आपने अगर नाम नहीं लिखा, then how could you say that it is silent? जैसे आपने deed बनाया और said that I give my property to dash. So in this situation, they are not silent. They are deliberately leaving the name of the donee. So उस kind of situations में the proviso will not apply. But if generally there something in which we have missed out by mistake और उसके लिए अगर oral agreement है, then the proviso too will apply. अब यहीं पर एक point बताना चाहता हूँ मैं आपको कि that contract could be oral or written. जरूरी नहीं है कि कॉन्ट्रैक्ट वो डिटेल्ड में हो. अगर कोई कार्ड है, किसी को आपने रुपए दिए, उसने किसी कार्ड पर लिख कर दे दिया आई रिसीव्ड 5 लाख रुपीज, तो दैट कुड बी ऑल्सो कॉन्ट्रैक्ट इतना सच ट्रीटमेंट एंड सर्टेन टर्म्स कैन बी प्रूव्ड बाय ओरल एविडेंस इफ देयर इज अ डिस्प्यूट. नाउ वन मोर पॉइंट टू से, सेक्शन 93 से 98 तक द वर्ड एविडेंस आर यूज्ड. एविडेंस may not be given or evidence may be given. They are not using the word oral or documentary. So documentary evidence तो है ही आपका. documentary evidence तो आप दे ही सकते हो किसी भी चीज को proof disprove करने के लिए. But we are here concerned with the oral evidence. So I have talked about the oral evidence, but it is nowhere written that we cannot give in the documentary evidence. It can always. So here the word evidence means both oral or documentary. बट उसी तरीके से अगर हम इधर डॉक्यूमेंट्री एविडेंस देखें तो द लैंग्वेज यूज्ड इन ए डॉक्यूमेंट ऑन फेस एम्बिगुअस और डिफेक्टिव, देन डॉक्यूमेंट्री एविडेंस में नॉट बी गिवन ऑफ द फैक्ट्स. तो ऐसा तो हो नहीं सकता, क्योंकि अगर कोई डॉक्यूमेंट एम्बिगुअस है या डिफेक्टिव है, उसके बाद कोई नया डॉक्यूमेंट बनाया गया, देन दैट डॉक्यूमेंट विल लेटर डॉक्यूमेंट विल बी इफेक्टिव, नॉट द प्रीवियस वन. और सूट हो गया प्रीवियसली डॉक्यूमेंट पे, तो ऑब्वियसली उसके लिए तो एविडेंस, डॉक्यूमेंट्री एविडेंस दिया ही जा सकता है. सो दैट इज व्हाई आई हैव सेड दैट वी आर टॉकिंग अबाउट हियर फॉर द ओरल एविडेंस. नाउ लेट्स सी सेक्शन 165. द जज मे इन ऑर्डर टू डिस्कवर or to obtain proper proof of the relevant facts. The judge may, in order to discover or to obtain proper proof. So you see the purpose of this section. The judge may, in order to discover or to obtain proper proof of relevant facts. क्योंकि देखो judgment will be depend upon the relevant facts which are duly proved. And in order to find the relevant facts का truth, in order to find the truth of the relevant facts, the judge may take the following proceedings. In order to discover or to obtain proper proof of relevant facts, the judge may ask any question he pleases in any form. In any form means what? It can be leading question also. It can be any other kind of question also. At any time, in any form, at any time of any witness or of the parties about any fact, relevant or irrelevant. So you see a list of powers, because ultimately you see that the judgment is based upon the discretion of the court, and judge has to do the ultimate justice into the case by deciding the case correctly. So therefore, parties are duty bound to produce evidences, documents, etc. But the judge has ultimately the power in order to discover the real proof of a particular relevant fact. He has the power to ask any question to any witness or to any party, and the question can be in any form, and that too at any stage of the proceeding. Suppose today a witness came, he gave his testimony and cross-examined by the opposite party. Then he has gone back. Then after some more evidences, maybe some after 5-6 months, the judge relates its back. By some further evidence, the judge relate backs and records that that witness has stated so and so, and there could be further clarification by him. So I need to be examine him once again, and let me examine him once again. Let me ask some more questions. Then the judge will, in the 311 CRPC, issue a summons to that witness to appear again. And when he appears again, and the summons to appear is in 311 CRPC. That is not in this section. Summons to appear will be in 311 CRPC. And therefore you see 165 Evidence Act and 311 CRPC are the complementary provisions. So judge will issue summons to that party, the witness. And when the witness appears, the court will be free to ask any questions, and those questions are not limited to relevant facts. The judge can ask him even irrelevant questions, but the judgment will be never based upon relevant facts. तो कई बार आप relevant सवाल पूछकर relevant fact का प्रूफ निकालते हो, तो वो भी आप कर सकते हो, लेकिन अल्टीमेटली जजमेंट हमेशा relevant facts पर बेस्ड होगा. तो पढ़िए इसको फिर से. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact, relevant or irrelevant, and may order the production of any document or thing. Production of any document or thing मतलब सिर्फ वो क्वेश्चन ही नहीं पूछ सकता है, वो कोई ऑब्जेक्ट और कोई डॉक्यूमेंट भी अपने सामने प्रोड्यूस करवा सकता है. जैसे संतोष सिंह के इसमें, suppose that helmet which is used for hitting, suppose the prosecution had not produced that helmet before the court, then the court can order the production of that helmet to make up its own mind whether this helmet may have been used to hit the victim or not, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order. मतलब जज जब क्वेश्चन करता है तो पार्टी ऑब्जेक्ट नहीं कर सकती. जज ने कोई डॉक्यूमेंट या थिंग कोई प्रोड्यूस करवाया है, सम्मन किया है, then the party cannot object. Neither of the parties can raise the objection to such orders, nor without the leave of the court to cross-examine any witness upon any answer given in reply to any such question. What happens is, suppose W is a witness. Now he has been summoned by the prosecution, suppose. Then the prosecution will be asked him the questions in examination in chief. So पहले examination in chief पे सवाल पूछ लेता है. Then the defense will ask the questions on cross examination. So जो सवाल prosecution ने पूछा, तो prosecution तो अपना सवाल पूछेगी examination in chief से related. तो otherwise जो cross examination का right होगा वो होगा defense का. अब defense है जो वो they can ask the questions based upon these questions which are in examination in chief by the prosecution, or they can ask any other question related to relevant fact. Now the court is also sitting there, the judge is also sitting there. Now suppose the judge puts the question number 1 and 2 to the same witness, and the witness makes replies to these questions. Now the point is, first of all, the judge has the discretion to ask any question to the witness, relevant facts or irrelevant facts. Then when the reply is given by this court, reply given by the witness in the court, जो कोर्ट के क्वेश्चंस थे, या उन क्वेश्चंस पे जो रिप्लाई है विटनेस का वो डिफेंस के खिलाफ जा रहा है, मान लो। अब डिफेंस चाह रहा है मैं उन सवालों पर विटनेस को क्रॉस एग्जामिन करूं। अब प्रोसिक्यूशन ने अगर सवाल पूछे होते तो डिफेंस के पास राइट था कि वो सवाल पूछ सकता है। बट इफ द क्वेश्चंस आर आस्क्ड बाय द कोर्ट, द डिफेंस डज नॉट हैव द राइट्स टू क्रॉस एग्जामिन। द क्रॉस एग्जामिनेशन will be done by the defense only when the court allow the defense to do cross examination. अब सपोज कोई विटनेस आया, प्रोसिक्यूशन ने 5 क्वेश्चन पूछे उससे। 5 क्वेश्चन पूछने के बाद अब 2 क्वेश्चन कोर्ट ने पूछ लिए प्रोसिक्यूशन विटनेस से। Then the defense is having the right to cross examine the prosecution witness upon first 5 questions. That is the right of the defense. But if the defense want to cross-examine the witness for the 2 questions which are asked by the court, मान लो 5 तक तो हो गया जो prosecution ने पूछा, 6 और 7 कोर्ट के द्वारा पूछे गए। So the questions number 6 and 7 are asked by the court. So the defense is not having the right, and therefore the defense has to apply to the court seeking permission to cross-examine upon those 2 questions. And it is the discretion of the court that the court may or may not allow the defense to cross-examine upon those 2 questions which is asked by the court. अब उसके बाद first proviso आ जाता है, in which they are saying even if the court can ask upon the irrelevant questions also, but the judgment has to be based upon the relevant facts and that too duly proved. तो इसको हम पहले भी देख चुके हैं इस प्रोवाइजो को। फिर उसके बाद नेक्स्ट में कह रहे हैं द अबव विल नॉट अप्लाई टू द फॉलोइंग केसेस। तो इसमें अगर प्रिविलेज्ड कम्युनिकेशंस हैं या 148 149 वाले क्वेश्चंस हैं या फिर सेकेंडरी और प्राइमरी एविडेंस हैं, वहां पर दे आर सेइंग दैट द पावर टू द कोर्ट इज लिमिटेड। The powers of the courts will be limited in these cases. जैसे अगर privileged communication में evidence prohibited है तो कोर्ट के पास भी 165 में पावर नहीं है कि कोर्ट वो वाले सवाल पूछ सके। या फिर secondary evidence will be given only when the section 65 is satisfied, and the court does not have the power to ask for the secondary evidence even if the section 65 is not satisfied. So that is what they are writing. 3 exceptions they are talking. तो पढ़ लो एक बार। Provided also that this section shall not authorize any judge to compel any witness. Provided also that this section shall not authorize any judge to compel any witness to answer any question, or to produce any document, which such witness would be entitled to refuse to answer or to produce under sections 121 to till 131. Now 121 till 131 is what? Privileged communication. तो अगर privileged communication में लिखा है that the particular testimony cannot be given, तो कोर्ट के पास भी 165 में पावर नहीं है कि वो विटनेस से वो वाला टेस्टिमनी ले सके। If it is written that husband cannot be compelled to give testimony against his wife, whatever she has communicated to him, then even the court cannot compel the husband to give the testimony on that statement. Even the court cannot compel the husband to give the testimony on that statement. So that is one limitation. Then they are further saying, nor shall the judge ask any question which it would be improper for any other person to ask under section 148 or 149. अब 148, 149 talks about the improper questions in the course of cross-examination and clearly says that the improper questions cannot be asked. तो पार्टी अगर improper question नहीं पूछ सकता 148, 149 में, तो कोर्ट भी वो सवाल 165 में नहीं पूछ सकता. Then further they are saying, nor shall he dispense with primary evidence of any document except in the cases herein before accepted. Means primary evidence will be exempted or accepted when the section 65 will fulfill. So if the section 65 is not applicable, then the court does not have the power under 165 to summon for the secondary document. अगर 65 प्रूव नहीं हो रहा तो कोर्ट के पास पावर नहीं होगा सेक्शन 165 में कि वो सेकेंडरी एविडेंस ले सके, उसको प्राइमरी एविडेंस ही लेना पड़ेगा. सो दीज आर 2-3 लिमिटेशन अपॉन द पावर ऑफ कोर्ट. जितने लिमिटेशंस यहाँ लिखे हैं उतने ही लिमिटेशंस हैं, उसके बियॉन्ड कोई लिमिटेशन नहीं है. उसके बियॉन्ड द पावर इज अनलिमिटेड. और एक ये लिमिटेशन है जजमेंट के ऊपर, दैट जजमेंट मस्ट बेस्ड अपॉन द रेलिवेंट फैक्ट्स व्हिच इज ड्यूली प्रूव्ड. इसके अलावा कोई लिमिटेशन कोर्ट के पावर पर किसी भी तरीके का कोई लिमिटेशन नहीं है. एंड कोर्ट इज हैविंग द ब्रॉड पावर्स टू आस्क क्वेश्चंस, to summon document etc. because ultimate duty to do justice in the case lies with the court. अब एक पॉइंट बताता हूं मैं आपको. कोई भी ऑब्जेक्ट अगर आप प्रोड्यूस करते हो कोर्ट में, दैट विल बी अ डॉक्यूमेंट्री एविडेंस. सिर्फ जो विटनेस का एग्जामिनेशन होगा दैट विल बी ओरल एविडेंस. बाकी का कुछ भी आप जो प्रोड्यूस करते हो दैट विल बी फॉल ब्रॉडली अंडर द डॉक्यूमेंट्री एविडेंस. So you see section 165 is basically about the inquisitorial proceedings. Inquisitorial proceedings means the proceedings in which the judge will also participate in order to find the truth of the case. What happens in the case is, suppose there is a suit between A and B. Now A produces his evidences, his witnesses, documents, and B also presents his witnesses and documents. Now the judge not only rely upon those witnesses or documents presented by the party concerned, the judge is having the power to ask question in section 165 by itself. He can also summon a document. Similarly, when you read section 311 of CRPC, the judge has the power to summon a witness for himself for his satisfaction. If he deemed prudent that the particular witness has to be examined, he can summon the witness and examine the witness himself also. And the purpose was always written in the beginning of the section itself, and that is, the judge may, in order to discover or to obtain proper proof of relevant facts. The purpose of section 165 is to obtain the proper proof of relevant facts, and for that purpose the judge has the power to ask questions to the parties, to the plaintiff and the defendant, or to the accused or the complainant in a case, and he also has the power to ask questions to the witnesses. So he can ask the questions to the party directly or to the witnesses. Now suppose the witness is called by the prosecution and the witness is being examined by the prosecution and cross-examined by the defense. So there the court also has the power to ask questions, whatever the court deems proper, to ask question to those witnesses. Similarly, the judge also has the power to summon any document. So whenever the court asks the questions to the parties of the witnesses or the witnesses, whenever ask question to the parties or to the witnesses or summons a document, a party cannot object to that. The judge can even go to the extent of asking irrelevant questions or questions upon the irrelevant facts. Now the party does not have the power or right to ask questions upon irrelevant facts, because the judgment has to be based upon only relevant facts. But the court has the power to do so, and if the court asks questions upon irrelevant facts, the party cannot raise objections to that. Now suppose there is a prosecution witness number 2 appears into the case. Then first of all he was examined in chief by the prosecution, then cross-examined by the defense. Now suppose the court under 165 puts two questions, question number 1 and question number 2. Now suppose answer to that question goes against the accused. The two questions which is asked by the judge, the answer to that question goes against the accused. Then does the defense accused has the right or power to cross-examine the witnesses upon those two questions? The answer is no. The court is having the discretion to allow the cross-examination or to not allow the cross-examination upon those two questions. वो लिखा हुआ है इसमें, तो read it again. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form. In any form means what? In any form means it can be a leading question also. In any form, at any time. At any time. Now suppose a witness is in examination in chief. There also the court can ask questions. If the witness is going on under cross-examination, there also the court can ask questions. Or the witness is gone under examination in chief and cross-examined and gone back. Then the court later on under section 311 CRPC can summon the witness again and then can ask the questions to the witnesses. Of any witness or of the parties at any time, in any form, at any time, of any witness or of the parties about any fact, relevant or irrelevant. So the questions can be upon relevant facts or upon irrelevant facts as well. And may order the production of any document or thing. So that is the summon for the production of document or thing. And neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court, means without the permission of the court, to cross-examine any witness upon any answer given in reply to any such question. So ये part मैंने आपको बताया अभी कि to cross-examine any witness upon any answer given in reply to any such question. Which question? Question asked by the court. Suppose a witness came on the side of the prosecution. He would be first examined in chief, which is done by the prosecution. Then after the examination in chief, the opposite party defense having the right to cross-examine the witness, and for that there is no need to take the permission from the court. They per se do have the right to cross-examine the witness. So the cross-examination as a matter of right is done by the defense. But suppose if some questions are put by the court to that witness, then there the defense is not having the right to cross-examine the witness. There the defense can cross-examine only with the permission of the court. मान लो कोर्ट विटनेस से प्रोसिक्यूशन विटनेस से 10 सवाल पूछे गए, उनमें से 8 सवाल प्रोसिक्यूशन ने पूछा, लेकिन सवाल नंबर 9, क्वेश्चन नंबर 9 और 10 कोर्ट ने पूछा. तो 8 सवाल का तो आप क्रॉस एग्जामिनेशन डिफेंस कर सकता है, लेकिन जो क्वेश्चन नंबर 9 और 10 है उनके क्रॉस एग्जामिनेशन का राइट डिफेंस के पास नहीं है. The defense has to seek permission from the court. So that is what comes out from the first part. Now see the provisos. Provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. because they are allowing the court to ask even the irrelevant questions. Even if the court can ask the irrelevant questions, but the judgment must be based upon the relevant facts only, which are duly proved. And then thereafter they are putting three limitations. Next proviso, provided also that this section shall not authorize any judge to compel any witness to answer any question or to produce any document which such witness should be entitled to refuse to answer or produce under sections 121 till 131. Means those matters which fall under privileged communication. Those matters which fall under privileged communications. In these cases, parties are bound not to ask questions. So this is the limitation from 121 till 131 upon the parties. The same limitation will apply upon the court also. For example, say section 122. The husband cannot be compelled to reveal what his wife has communicated to him, and vice versa. So a party cannot compel a husband as witness, and the court also therefore, despite section 165 first para, the court therefore also cannot compel the witness to the husband to reveal those communications. Both inclusive. Then further they are saying, produce under document any document under sections 121 till 131, both inclusive, if questions were asked or the documents were called for by the adverse party. Then further they are saying, nor shall the judge ask any question which it would be improper for any other person to ask under section 148 or 149. 148 and 149, when you read, you will find that they are providing certain questions which are improper, and the court will not allow a party to ask such questions. So if a court cannot allow a party to ask such questions, then the court itself cannot ask such questions. So that is only with respect to 148 or 149. Then lastly they are saying, nor shall he dispense with the primary evidence of any document except in the cases herein before accepted. Except in the cases herein before accepted. Now you must appreciate in section 65 of the Evidence Act allows the production of the secondary evidence, and if a matter does not fall under section 65, then the secondary evidence will not be allowed. So even under section 165, the court has the power to summon and document etc., but it cannot summon the secondary evidence unless the matter falls under 65. So write down, the court has the power under section 165 to summon the production of any document. However, as per the second proviso, even the court cannot summon a document as a secondary evidence unless the production of such secondary evidence is permissible under section 65 of Indian Evidence Act. So this is about the production of document, when it would be permitted to court also to produce a secondary evidence. Now write down the general dictation upon section 165. Section 165 is also a part of cardinal principles of the law of evidence. It provides for the special power of the court to obtain the best evidence in the suit or proceedings. It is an aspect of inquisitorial proceedings. That is, it is the duty of the court to deliver the best judgment and to serve the interest of justice in the peace. The court cannot remain dormant and rely upon the evidences produced only by the parties. The court rather has to be proactive, and if the need arises, it does have the power to summon documents or things and to ask any question for its own satisfaction. The purpose of Section 165 is to enable the court to find or discover the truth of the facts alleged in the case, and for that purpose to find the proper proof regarding those facts. The proceedings of Section 165 are considered to be indicative evidence or evidence of evidence. Now, what is the meaning of indicative evidence or evidence of evidence? So what this mean is here is, मान लो एक प्लेंटिफ है या डिफेंडेंट है, उसने अपने अपने एविडेंसेस दिए. अब कोर्ट को अपने लिए फॉर इट्स सेटिस्फैक्शन 100% सेटिस्फैक्शन ड्राइव करना है कि वो एविडेंसेस विश्वसनीय है, विश्वास योग्य है. Court has to derive 100% satisfaction for itself that the evidences are trustworthy, and it enables the court to decide the case. So for that purpose, maybe the case that evidence is sufficient, or maybe the court has some doubts. So there the court will put some questions to the witnesses or for some documents, etc. So these questions and the answer of these questions is given by the witnesses and the parties. So these answers will indicate the truthfulness of these evidences. These answers will indicate the truthfulness of these evidences, whether these evidences are reliable or not. So that is where you say that these answers that the court obtains by asking those questions of Section 165, they give the evidence of the truthfulness of these evidences, or these indicate the truthfulness of these evidences which are being produced by the parties. And that is where you will say that it is indicative evidence or evidence of evidence. And next para. The court under Section 165 has the power to ask any questions to any party or to any witness. The questions here may even be upon some irrelevant facts, though the court cannot base the judgment upon such irrelevant facts. The party does not have a right to object to such questions or summons issued by the court, as that is a discretionary power of the court. These questions are asked by the court in order to make the evidences produced by the parties more intelligible, means more understandable. The questions can be asked to the parties directly even if they are not appearing as a witness, or it can be asked to any witness or even to a party appearing as a witness. अब कई बार क्या होता है, जैसे किसी केस में मान लो कोई क्रिमिनल केस है और उसमें एक पार्टी तो विक्टिम होगा और एक होगा एक्यूज. उसी प्रकार से सिविल में एक होगा प्लेंटिफ और एक होगा डिफेंडेंट. क्रिमिनल केस में एक विक्टिम होगा, एक एक्यूज होगा. अब क्रिमिनल केस में दिस विक्टिम इज द प्राइम विटनेस. He will appear into the as a witness into the case if he is alive or she is alive. So when he appears into the court can ask questions to him as a witness. Now, accused is not a witness. Accused cannot be a witness. Accused is the person who committed the crime, so he cannot be a witness in the case, except some situations जो कि given है in 315 CRPC. There are certain situations in which the accused can be also a witness. अब मान लो किसी केस में accused witness नहीं है, सिर्फ एक accused है, लेकिन पार्टी तो होगा विक्टिम और accused दोनों पार्टी हैं. कोर्ट के पास पावर है कि 165 में बुला के डायरेक्टली उससे सवाल पूछ सके. या फिर मान लो एक्यूज्ड विटनेस बनकर अपियर होता है कोर्ट में 315 में, पार्टी उसको एग्जामिन कर रहा है, तो कोर्ट चाहे तो उसको 165 में सवाल पूछ सकती है। मीन्स इफ द पार्टी appearing as a witness, then also it can be examined by the court, and even if any of the parties not appearing as a witness, then also the court can directly examine him as a party. Means that power the court is having under 165 of the Evidence Act. Similarly, when talk about civil cases, if you have read the Order 18 Rule 3A, it is clearly provided that the plaintiff or defendant can appear as a witness, but he will have to appear as a first witness. तो विटनेस बनकर ये अपीयर हो सकते हैं। तो मान लो अगर कहीं पर विटनेस बनकर अपीयर हुआ तो कोर्ट उसको 165 में एज ए विटनेस एग्जामिन कर सकता है, और मान लो अगर प्लेंटिफ खुद विटनेस नहीं बनता है तो कोर्ट उसको एज ए पार्टी उसको 165 में एग्जामिन कर सकता है, बिकॉज द कोर्ट हैज द फ्रीडम टू आस्क क्वेश्चंस टू द पार्टी directly even if he is not appearing as a witness, or if a party converts into a witness, then as a witness also the court can ask questions, examine, and otherwise also if other witnesses appears in a case, that other witness can be examined in the case by the court. तो इसी तरीके से सिविल में कुछ प्रोविजंस हैं, ऑर्डर 15 है, ऑर्डर 16 है, ऑर्डर 18 है, रूल 3 है, ऑर्डर 18, वेयर द पार्टीज कैन बी ए विटनेस, और कोर्ट के पास पावर है। अगर आप विटनेस बन के आए तब तो कोर्ट एग्जामिन कर ही सकता है, कोई विटनेस हो या फिर पार्टी विटनेस बन के आए तो एग्जामिन कर ही सकता है। बट अगर पार्टी विटनेस नहीं बनता है फिर भी कोर्ट उसको सम्मन करके डायरेक्टली उससे सवाल पूछ सकती है, अगर कोई पार्टी विटनेस नहीं होता तब भी, because they are clearly writing in 165 that any question in any form to any witness or of the parties, तो पार्टीज को भी पूछ सकता है कोर्ट और विटनेसेस को भी पूछ सकता है। अगर पार्टीज विटनेस बन जाए तो विटनेस को एग्जामिन कर सकता है ऑफ एनी विटनेस, और अगर पार्टीज विटनेस नहीं बनता है देन ऑफ एनी पार्टीज। सो राइट इट डाउन। In suit or proceedings, a party may appear as a witness as well, and if he does so, the court has power under section 165 to ask questions to him directly as a witness. However, even if the party does not appear as a witness, it can be examined directly under section 165. The court can ask any question in any form. It can ask leading questions, relevant questions, or even questions on such facts which will amount to hearsay evidence. But the judgment has to be based upon the relevant facts and not upon the irrelevant facts or hearsay evidence. Because hearsay evidence admissible नहीं होता। अब मैंने खुद ने नहीं देखा, किसी और ने बताया, that is not admissible in the as evidence. अब कोर्ट उसके लिए मुझसे सवाल पूछ सकता है, बट उस पर अपना जजमेंट बेस नहीं करेगा। For its own satisfaction, court can ask question, but cannot use that as to pass the judgment. Now write down some cases. Nepal Chandra Roy versus Netai Chandra Das, 1977 Supreme Court, and State of Rajasthan versus Aini, 1997 Supreme Court, Ramchandra versus State of Haryana, 1981 Supreme Court. अब इन सब केसेस में एक ही पॉइंट है, एंड द पॉइंट इज कि किसी भी विटनेस के सबसे पहले किसी भी विटनेस का एग्जामिनेशन इन चीफ होगा, उसके बाद क्रॉस होगा, और उसके बाद अगर अदर पार्टी चाहे तो, ओरिजिनल पार्टी अगर चाहे तो री एग्जामिनेशन होगा जिसका वो विटनेस था। अब इनमें कोर्ट अपना सवाल कब पूछेगी, If the court has some questions, then at what stage the court shall ask? I am not saying the court can ask. Court can ask at any stage. The court can ask any time, but what does the prudence require? That should the court ask the question at any point of time, or should the court wait for to get the cross-examination over? Should the court wait for to get the to get over the cross-examination? अब practically देखें, the court has the power to ask question at any point of time. जैसे कोई विटनेस आया एग्जामिनेशन इन चीज के लिए, तो वकील साहब को रोक दिया कोर्ट ने कि आप रुक जाओ, पहले मैं पूछूंगा, आई एम द कोर्ट. देन ही स्टार्ट आस्किंग द क्वेश्चंस. और जितने भी पॉसिबल क्वेश्चंस वकील साहब पूछ सकते थे वो सारे पूछ लिए. फिर क्रॉस वाले में भी जो वकील साहब आए उनसे बोल दिया कि पहले रुक जाओ, मैं पूछूंगा. तो फिर वकील दोनों एडवोकेट्स का तो कुछ काम ही नहीं रहा. सो द पॉइंट इज, shall the court be more enthusiastic? Shall the court be over enthusiastic? So the answer is no. The court can ask questions, but it can ask questions, those questions which the parties have not asked and which the court believes that parties ought have to be asked, and answer to those questions is important to deciding the case. So therefore the answer to this question is that the court should not be over enthusiastic or overzealous. Court unnecessarily overzealous or enthusiastic नहीं होनी चाहिए. That I will ask questions, कि मैं ही सारे questions पूछूंगा. That the court cannot do. Court has to be selective in asking the question. Let the parties ask their questions first, and then if the court finds then there is something more to be asked, then the court may ask questions. तो पार्टियों को क्वेश्चन पूछने के बाद अगर कोर्ट को लगता है there is something more to be asked which will help to give the judgment, then the court can ask. But that does not mean that in between the court does not ask, cannot ask. Court has the power. For suppose right now a question is asked by a party. Now in practical, the court can ask a question. In practical, that question can be put to the witness there and then, because that question relates to the question asked by that other party. So in that case, the court cannot wait for the subsequent examination, etc. And the court can ask question in between also. But normally, the rule of prudence requires that you must ask questions after the cross-examination gets over. So ये एक issue आता है, and for this issue, these are the some cases. So write down upon this issue. Right? The court shall not be overzealous or over enthusiastic in asking the questions. It shall not unnecessarily interfere in the examination being conducted by the parties. It is necessary that the court and the counsels should act as a team in the interest of justice. The court shall allow parties to ask questions effectively first. Rule of prudence requires that the court shall put its questions only after the questions have been asked by the parties. However, it is only rule of judicial prudence. The court doesn't have the power to ask the question at any stage. However, it is only a rule of judicial prudence. The court does have the power to ask the questions at any stage. But सवाल पूछना लास्ट में ज्यादा बेहतर होगा, क्योंकि एक पार्टी ने अपने सारे सवाल पूछ लिए. तब आपको अगर लगता है कि कुछ और रह गया है पूछने के लिए, तो आप पूछ लो. बट अगर आपने बीच में ही या पहले ही क्वेश्चन पूछना चालू कर दिया, तो यू डोंट नो व्हाट द questions the party is going to ask, then in that situation it is unnecessary to ask the questions, because if the party also want to ask same questions, that would be a wastage of time, and that may amount to assisting the parties as well. तो parties को पहले question पूछने दो, सवाल पूछने दो. If you have asked the question which parties ought to have asked, then you are assisting that party. So better you refrain from asking those questions. It will better to ask questions in the end when the examination process is over. But that does not mean that you cannot ask questions in between. You do have the power, and if it appears at any stage, you can put questions to witnesses. मान लो जज साहब ने जो उसमें आके विटनेस को धमकी देना शुरू कर दिया कि सच सच बताना वरना जेल में डाल दूंगा. देन कैन द जज इज अलाउड टू डू दैट. धमकी देना जैसे कि मैं तुमको जेल में डाल दूंगा अगर जवाब नहीं दोगे, फांसी पे चढ़ा दूंगा. सो जज कैन नॉट बी एक्टिंग इन दैट मैनर. If you are having the power, then you have to exercise your power in such a manner so that the dignity of judiciary be maintained. So उस तरीके की धमकी आप नहीं दे सकते simply because you are having the power in 165. Now write down another means on asking the questions. Question पूछने के लिए court should not be overzealous. Other case Raghunandan versus State of UP 1974 Supreme Court. इसमें हम 165 को रीड करेंगे विद 162 ऑफ CRPC. सो इसका एक इशू है that we would discuss it into the next lecture. So thank you for watching this lecture, and that's it for this lecture. For now just write down this case, Raghunandan versus State of UP 1974 Supreme Court. We would discuss it into next class.